Good afternoon, everybody, and thank you to the National Safeguarding Office and the Department of Nursing and Midwifery in Trinity College for inviting me to participate today in World Elder Abuse event, which is an extremely important issue. So my brief is to look at the issues why safeguarding legislation is needed to protect the rights of older people, and I'm going to talk generally, obviously, about safeguarding legislation with particular emphasis on some issues around older people. So first of all, very briefly, just to state what the objective of Safeguarding Ireland is. We were established in December 2015, and we are an independent body and a registered charity. Why we need a legal framework around safeguarding, and as I said, some specific issues in relation to older people in particular, and then to look at some specific issues in relation to safeguarding legislation. So the main object of Safeguarding Ireland is to promote safeguarding of adults who may be vulnerable, protect them from all forms of abuse by persons, organisations and institutions, and develop a national plan for promoting their welfare. And our strategic plan for 2020 to 2025 is the pursuit of the introduction and enactment of adult safeguarding legislation and the establishment of a national independent adult safeguarding authority. So some of the points I'm talking to today are taken from our recent document, which Mandy referred to earlier, which is a discussion document, identifying risks, sharing responsibilities, the case for a comprehensive approach to safeguarding vulnerable adults. And the reason we did this paper was that since we were established in 2015, we've done a number of national surveys of issues, and there are huge gaps in understanding even the need for adult safeguarding. We have child safeguarding, we've heard already today, but we have no adult safeguarding framework at all. So we have picked up some of those issues, and there's a huge gap in the knowledge of the legislators, of professionals, of families and of individuals, of this huge gap that we have. So we're hoping that our paper will inform you, and it is on our website. So first of all, some of our research findings. So one of our very early studies in 2016, the Irish public believes abuse of people in vulnerable situations is widespread. And research then in 2020, 12% reported having experienced abuse in the previous 6 months, and 1/3 of adults said they had experienced abuse in their lifetime. And almost 1 in 4 do not know who to report abuse to. And we did a separate survey on reporting, and the figures are quite stark, so that we don't have any central repository to report to. The public want a 24-hour helpline. And in Safeguarding Ireland, we are not at operational level. We are a policy body, really, and looking for the enactment of adult safeguarding. We get quite a number of queries from all aspects of society, not mainly health and social care. So it's a really important issue. 91% supported stronger laws to safeguard people from abuse or neglect, and 85% were supportive of an independent national authority for adult safeguarding. So some of my red asterisks at the end of sentence are really particularly in relation to older people. But we have an absence of a uniform regulatory framework, legislation or policies, accountability and enforcement across all settings. There's limitations on the role of the HSE safeguarding service. That limitation applies within the HSE itself, apart from applying outside the HSE to other settings. The absence of the regulation of home care services. In 2011, the Law Reform Commission published a report recommending the regulation of home care, where how many years later, HICWA produced a report last year, again looking for regulatory reform, and I understand the Department of Health are to issue a consultation paper in the next day or so. So the length of time it takes from say a recommendation or a report is just unacceptable in many issues that we deal with, as you know, in Irish life, but particularly around safeguarding very vulnerable people. We have a limited form of protection afforded by regulation of nursing homes. We saw that from COVID in spades. So there are huge issues there. We have limited obligation to disclose information about certain types of abuse. We have the criminal law disclosure of information, which is very limited to limited sexual offences, but not in terms particularly of older people, where we trivialise abuse or we don't even see the abuse of older people. We've limited powers to enter premises and access information and investigate concerns. And it's one of the issues that the Law Reform Commission in their issues paper has raised again, and Safeguarding Ireland has certainly raised that issue, and I know the HSE has in the past as well. So that's a glaring gap in the legislation at the moment, where you have a person in an unsafe environment. We need to challenge the widely held belief that family members of persons at risk are entitled to manage and exploit the finances and assets of their next of kin in the absence of proper authority. Again, a survey Safeguarding Ireland did about 2 years ago, 57% of the Irish population think they can make a decision about a person who is old and frail, whether they have capacity or lack capacity, and they can make that decision without the consent of the older person. So we have a huge cultural gap to fill in relation to some of that. We've no overall regulatory body with responsibility for receiving complaints. And we find that in Safeguarding Ireland as a huge issue, where we can't provide that service. No national database for the collection of adult safeguarding issues of concerns, leading to critical gaps in information to inform policy and legislation. And a couple of years ago, about 3 years ago, the Court Service did a manual survey, if you like, to find out how many older people were making applications for safety or protection orders, and a high 27%, but they don't keep data again on that. So again, the dearth in the collection of data to inform what we really need to put in place. No regulatory body with responsibility for and powers to investigate individual cases of abuse reported in residential care settings. So the Brandon report screams out in relation to that gap. So gaps in the statutory provisions then, we've no social care legislation. There are no clear obligations on the state agencies or organisations to prevent harm or generally to protect adults at risk. That can be compared with the UK legislation where they have those obligations. So there must be a statutory obligation on state bodies to do more than simply respond to crisis. And that's where we're great at. We're responding to crisis. We throw money at responding to crisis, but we don't learn from the crisis that we've actually spent money on, instead of putting that money into creating a proper framework. And we must have accountability and take steps which prevent adult abuse and uphold a person's rights. We've no statutory framework for interagency, cooperation, collaboration and data sharing. And Safeguarding Ireland has participated over the last year and a half with 5 nations' jurisdictions. They all have that facility in place, with the exception of ourselves. There's no statutory obligation to report abuse, violence, exploitation or neglect perpetrated against a person at risk. And as I've already said, we tend to trivialise abuse perpetrated on older people and don't see it as abuse. We've no statutory provision for the offence of coercive control in a non-intimate relationship, and I'll come to that because I have a particular slide on it. We've no statutory provision on the protection of liberty safeguards, a huge issue for older people, and again I'll come to that. We've no statutory provision for independent advocacy, and yet it's part of our standards, HICWA standards, HSE standards and other standards, and we've no statutory provision for it. We've no statutory provision for dealing with self-neglect. We've no statutory provision for legal aid to create an enduring power of attorney. So if you can't afford to go to a solicitor, you are deprived because you financially can't afford that. A huge issue in terms of a safeguarding issue to ensure that a person can put in place legal authority and appoint somebody to make decisions on their behalf. So looking at then psychological abuse and coercive control, these are the figures from the HSE report just published for 2021. And the figure, as you see there, for the over 65s and the over 80s, surveys that Safeguarding Ireland has done would put those figures much higher than that. So for older people in particular, coercive control, psychological abuse is a huge issue. And of course, the highest levels of abuse occur, particularly on older people, occur in a person's own home. So the HSE figures are looking at older people's services in the HSE and disability services, but not looking at some of the wider issues in society. And then if you look, and that's, I was very pleased to see this figure in the report this year. It's the first time that the combined abuse of psychological abuse and financial abuse was highlighted. And as you see there, again, a very high figure of 30% for the over 80s. And I'm involved with SAGE advocacy. 80%, over 80% of SAGE advocacy's clients are over the age of 70. And the two issues, the two standout issues, are financial issues that older people need help with, and indeed the whole question where they're going to live and the deprivation of liberty. So financial abuse is huge, so that's why an EPA is so important, that a person can afford to make and create their EPA. So as I said there, underreporting is caused by a number of factors, but also the absence of a clear authority as who to report to. So reporting financial abuse to the HSE, where the HSE don't have any statutory function in relation to that. So they are gaping issues. And then the dearth of safeguarding and protection data generally is a critical gap. So while the HSE is collecting some figures in limited settings, what figures are the Department of Health, what figures are the Department of Housing, what figures are the Department of Social Protection, what figures are the Department of Finance, etc., and I could go on. So again, to inform policy and legislation around safeguarding, we need a proper national collection of data. So coercive control, just to highlight, and again, I was quite taken aback recently where somebody thought that we had a universal offence of coercive control. And just to say, you see from the legislation there, it is limited to a person who is a relevant person, is defined as a spouse, civil partner, or is not a spouse, but is or was in an intimate relationship. So all of those older people that are being psychologically abused or being subject to coercive control are not included in that legislation. And Safeguarding Ireland met the Minister for Justice recently, and we said to her a quick fix really is to delete that last definition of a relevant person and to redefine it in terms of the abuse, in terms of the behaviour. And again, if any of you have any influence, that is a really quick fix that can be dealt with and should be dealt with, and long before. Even when the domestic violence legislation was updated 2018, came into force 1st of January 2019, Safeguarding Ireland made this suggestion then. We're now, how many years later? 3 years later, and that fix is not there, and it should be. So on deprivation of liberty, just to say, it's a constitutional right. The Constitution provides that no person shall be deprived of his personal liberty save in accordance with law. That's really important. The European Convention of Human Rights provides the same, to say that no one should be deprived of his or her liberty save in accordance with procedures prescribed by law. And then everybody who is deprived of their liberty is entitled to take proceedings by which the lawfulness of his or her detention shall be decided speedily by a court. We don't have legal aid for older people. How many cases have been taken to the court in relation to these issues, which has been an issue for many years, and really people didn't understand. This is a constitutional right, it's a convention right, and again the UNCRPD also provides that a person shall not be deprived of their liberty unlawfully or arbitrarily, and that any deprivation of liberty is in conformity with the law. So where is our legislation? So the AC case, Cork University Hospital, and so I'm sure some of you have read or understand this case, an elderly lady who had appeared to have some capacity, but her son took an action in the sense that I know there were challenging family circumstances in that case, but she wanted to go home, and the hospital were concerned about her protection and wanted to detain her. So the Mr. Justice Hogan in the Court of Appeal says the application of the Constitution raises legal and constitutional issues of far-reaching importance regarding the personal liberty, not least insofar as the care and welfare of the infirm and elderly are concerned. And he said the right under the Constitution cannot be swept away by Victorian wardship legislation. And even since that case, we've had a huge increase of applications to wardship to take a person in, to deprive them of their liberty because they do not want to go to a nursing home or a care centre. So he said it is a legal issue, not a medical issue, and Article 40(4)(1) provides that all detention must be in accordance with law, and the reasons and motives of the detainer are not relevant to any consideration of this issue of law. So we need a legal framework. And he then went on to say that the power to detain a person claimed by the hospital amounts to a paternalistic entitlement to act in their best interests, and particularly of patients whose capacity is at issue, and in effect to restrain their personal liberty and freedom of movement, and if necessary to do so at the expense of close family members. But he pointed out that even before the Constitution, the common law has always rejected the claim that personal liberty could be compromised on such a basis. So very clear articulation by the court of the need for a legal framework. That case was appealed by the HSE to the Supreme Court, and Ms. Justice Isilda O'Malley gave the leading judgment there, and she says, I consider that the constitutional guarantee of the right to liberty protects people who, again, the court has to learn about the proper terminology, person who lacked decision-making capacity to the same extent as everybody else. Deprivation of liberty must in all cases be in accordance with law. She went on to say to hold that persons cannot be found to be detained if they are not capable of making a valid decision to leave for themselves, or if they are not aware of or able to object to their situation, would not simply permit restrictions on their freedom of movement for their own protection. It would also have far-reaching consequences of denying to vulnerable persons the benefit of their constitutional guarantee that they would not be deprived of liberty otherwise in accordance with law. And the Supreme Court decided that any case where a person was deprived of their liberty and they hadn't actually nominated or said or indicated their wishes with regard to that, that it had to be an application to the court. So hence the huge increase in applications to wardship since that case. Now, the court held in the Supreme Court that under the doctrine of necessity, that the hospital could detain a person, but for a limited period, and that period was 2 weeks, no more than 2 weeks. So we've no protection of liberty safeguard legislation, so the state is in breach of its human rights obligations, both under the Constitution and under the conventions that we have ratified. And then just to say that, of course, deprivation of liberty, their abusive practices are embedded in our culture and practice, and has the greatest impact on older people. And even the European Committee itself, on talking about Article 5, said that people didn't realise that putting a person in a nursing home against their will was actually a deprivation of liberty, and laws had to, and states had to understand that issue fully. So abusive practices still continue. Even last week I heard where some particular care facility did not understand this issue and was detaining a person and didn't understand that they had to make that application where necessary. So the will and preference of the person is not ascertained, or where they are ascertained, they're ignored. That decisions are made and the person is not consulted even when the person has capacity. So family members decide what's convenient for the family member, what's convenient for the finances of the family, etc. So that's why the whole issue, deprivation of liberty, fair deal, think of it in the round, all of these issues are tied up together, abusive practices. So we need to know and understand these issues. So as I say, associated with financial abuse and coercive control, the wards of court process is totally inappropriate. Again, it's a constitutional right. It should be dealt with as an independent constitutional right, not wrapped up in an unsound mind and a person unable to make their decisions. Just to say, in terms of the Assisted Decision-Making Capacity Act 2015, which is about to commence, hopefully, the Circuit Court would have no jurisdiction to deal with a constitutional issue or a Human Rights Convention issue. So that will be the High Court. And we'll see then the development of the legislation. But the clear direction contained by the Supreme Court currently is still being ignored, just to say that. Heads of a Bill was published in December 2015, but we still haven't seen any legal framework, and it is not provided for in the 2015 Act. It hasn't been provided for in the amending legislation published in November and debated in the Oireachtas at committee stage yesterday. My understanding is it has been worked on, but we still don't have any legislation. So on to safeguarding legislation then. Just to say again, there was a safeguarding bill introduced into the Senate by Senator Colette Kelleher in 2017, and of course that fell when there was a change of government. But it was reinstated on the statute book last year, but it hasn't advanced at all. So we and Safeguarding Ireland did contribute to that draft bill in 2017. So some of the issues that I'm talking about here is what we suggested back in 2017 and are still extremely relevant. So one is the need for an independent oversight body, and I'll come back to that. The need to broaden the issue of safeguarding vulnerable adults beyond the domain of health and social care. So a multidisciplinary approach to safeguarding is absolutely required. The need for safeguarding and protection service to have stronger rights of entry and inspection, and also to say that of course we need an independent safeguarding and protection service, and the HSE itself has confirmed that they're in agreement with that as well. So the need for better intra and interagency liaison and collaboration. The need to ensure that people who experience abuse in any form have easy access to safeguarding and redress where relevant. And the need to ensure that adults in nursing homes and in other residential care facilities are fully safeguarded and their legal and human rights are protected. So back to our National Adult Safeguarding Authority. This is one of our central recommendations in our discussion paper. And we also have diagrams there in terms of who that authority should govern, etc., and the whole question of its independence. So we're recommending that a National Safeguarding Adult Authority be established with overarching responsibility of safeguarding with clear statutory duties and powers, and the functions would include to promote standards, to undertake investigations, to receive reports from mandated persons. And again, we're not saying mandatory reporting, but again, that's an issue that needs to be absolutely debated and addressed as to what form of reporting we should have in this jurisdiction. And again, I refer you to the Law Reform Commission's issues paper of 2020, I think it was. Anyway, in terms of that debate, should we have mandatory reporting, should we have hybrid reporting or whatever, which means that of course certain particular abuses or offences are reportable and others not. But we need a proper, all organisations of course need a proper complaint system, and first of all, promote education, training and public awareness regarding matters concerning adults at risk, to provide information to adults at risk in respect of abuse and harm they may be experiencing. Who does a person go to now? Very, very difficult to direct anybody who to go to. And again, I experience that from the queries we get in Safeguarding Ireland. We find it difficult to who to send a person to in particular circumstances. Again, the functions of the authority should be to supervise compliance with the duties imposed by and under the legislation, provide information and guidance to service providers, organisations and bodies in the state in relation to their interaction with adults at risk, including the carrying out of risk assessments and safety statements. And again, even within the HSC, there are queries as who they should be dealing with in particular circumstances. So all of that, really important that service providers and professionals and organisations know exactly what the framework is, who they can refer to, who they can get actually good information from as to what to do and where to go. Also to determine if an adult needs support and assistance. Again, we had the Grace case, 18 years of age, fallen into a big black hole, no service for her or whatever. So, and that's happening many times over still after how many years we had the Grace case. Make provision where appropriate for independent advocacy to an adult at risk who's the subject of an investigation. Many older people now, certainly on the figures and the cases coming through that I see, are older people with maybe their families have gone abroad, are no longer around, or their spouse or their children, they don't have children. So people are living longer and they're living maybe on their own, or they've nobody else to assist them. So that independent advocate, and again where families are in conflict, really important to have an independent advocate who can provide their voice and assist them in relation to that. And then to provide overarching governance to a number of bodies who have a safeguarding remit. And that's, I think, a really important issue. So conclusion then, safeguarding is everybody's responsibility. Adult safeguarding legislation is needed. It must set out the principles which place human rights at the core of legislation around well-being, care, support and safeguarding. And again, I would emphasise the well-being and the care and support because that's where the prevention can happen and take place and ensure we're not ending up with a protection and safeguarding at the other end or the necessity for it. There are large gaps in the legislation, as I've just indicated, in practices, systems and organisations that are really very costly on individual lives. And to quote Lord Mumby again, so really, really important. And of course, we don't have a system that actually does respect the dignity of each person as an individual in his or her own rights, so really important. So there is an urgent need for the enactment of adult safeguarding legislation, and particularly for older people, I feel myself personally. So thank you very much.